right, this video is going to focus on how a case actually gets to the Supreme Court. The term that we use to describe is like jurisdiction. This just means like what court gets to hear the case, usually like first, right? So the Supreme Court actually possesses two types of jurisdiction. They have original jurisdiction, which they don't use very often. This means that the case actually starts in the Supreme Court, and they're the first court to actually hear the case. Again, this is really rare. This might happen like one or two times a year, if that. Like cases that the Supreme Court could hear the case first and have original jurisdiction would be if there were disputes involving officials from foreign governments, if there were disputes between states. So again, if the United States government was involved in some sort of dispute with an official from a foreign government, they could assume original jurisdiction. If there was a feud going on between two states, it's not likely, but they could assume original jurisdiction. So for example, in 1999, New York and New Jersey actually sued one another to determine who had possession of Ellis Island, because it's in the water between New Jersey and New York. The Supreme Court actually assumed original jurisdiction on this case, and they ruled in favor of New Jersey. But again, this is rare. Most of the cases come to the Supreme Court through what we call appellate jurisdiction. This means that a bunch of courts have already heard the case before it gets to the Supreme Court, and the Supreme Court's kind of hearing it last. So an example of this would be Timms versus Indiana in 2019. I could give you a million different examples. I just chose this one. This essentially was a case that originally went through Indiana's court system, and then jumped over to the Supreme Court. So other courts heard this case first. And basically what it involved was the state of Indiana had seized this individual's Range Rover in a drug stop. And the amount of drugs taken from the individual Timms was a small amount, but they confiscated his Range Rover, which was valued at over like $48,000 or somewhere around there. And Timms's argument was that this was like cruel and unusual punishment. It was like excessive fine for the crime that he was accused of. And it's an example of appellate jurisdiction because Indiana courts heard it first, and then the Indiana State Supreme Court heard it first, and then eventually it went to the Supreme Court of the United States. And after like a 2.5 year process, the Supreme Court finally ruled on the case, deciding in favor of Timms and against the state of Indiana's confiscation of the Range Rover. So, like, how many cases does the Supreme Court handle in a year? Not very many. You essentially could have thousands of cases that the Supreme Court could hear, but they choose not to. So you can see this is a little outdated. It only goes to 2012, but you can see how many cases they could hear versus how many they actually hear in a year. And it's usually in modern times like under 100 cases a year. So it's not your right as an individual to have your case heard before the Supreme Court. You definitely have a right to an appeal, but you don't have a right to appeal to the Supreme Court. Essentially, the Supreme Court justices have control over what cases they hear. It's one of the perks of being a Supreme Court judge. Essentially, what lawyers will do is they'll file for what's called a writ of certiorari. A writ of certiorari, I should say, essentially is a court order that the Supreme Court issues to the lower court to have them send up like all the records involving a case. And that's really like the sign to the general public and everybody else. The Supreme Court has decided to take that case. So lawyers essentially have to petition the Supreme Court, and then the Supreme Court needs to decide if they're going to take the case. So Supreme Court justices will meet several times a year, and they'll talk about the cases that potentially they could take, right? And individual justices have sort of issues that they maybe care about more than others, and oftentimes they'll get help from their clerks. Clerks are like relatively recent law school graduates that will work for the justices that really are the ones like going through the thousands of cases that are in the pool before them to potentially select cases. They'll do the research. If they know their justice cares very much about gender equity issues, then they'll go through all of the available cases, pull out the ones they feel like their justice will be most interested in, and then present the justice. And then the justice during the conferences will argue with the other justices about why that particular case should be accepted by the Supreme Court. In order to be accepted, you need 4 justices to vote to accept a case. We call that the rule of 4. So if the Supreme Court If of the 9 justices, 4 of them agree to take the case, they'll take the case. But you need to get at least 4 justices to agree to hear a case. That's called the rule of 4. And it definitely helps if, like, the United States government is the petitioner, meaning like they're bringing forth the lawsuit. The Supreme Court will take roughly 70% of the cases in which the government is actually like the one bringing forth the complaint. So that's something to consider. But basically, the justices will take these things into consideration. Again, if they take the case, they issue this what's called a writ of certiorari, which is this order basically saying that they've accepted the cases. So, like, what would make the Supreme Court like less willing to take the case? If it was like some sort of like absurd claim, it's just like utterly ridiculous. Like, they're not going to take the case, right? If it's like some sort of like frivolous, like not important issue that's really not going to establish anything of significance, they're not going to take the case. If it's not really a new kind of issue, the Supreme Court has already decided the issue or decided it recently, and a lot of stuff hasn't changed, they're probably not going to take a similar case. If the issue is like way too new and the Supreme Court doesn't really have a feel for the issue anymore, it's called lack of percolation, like the issue hasn't been around long enough, then they may not take the case either. So it's like an old issue or it's too new, they might not take the case. If this is kind of like a messy case and there's like a much better case that is like down lower in the judicial system that's weaving its way to the Supreme Court, then they might wait for that case and not take this one for some reason. Or if there's just like no way the Supreme Court could even come up with like a definable answer, they won't take the case, right? All right. So, like, what would allow the Supreme Court maybe to have the justices vote to take a case? Like, what would make it worthy of issuing a writ of certiorari? If there's like a clear conflict between lower courts, like the first court that heard it ruled one way and the appeals court ruled the opposite way, maybe it's more likely for the Supreme Court to jump in almost as like a tiebreaker because the lower courts really can't agree on how to deal with this. If the issue has the ability to affect a large number of people and it is like a significant issue, they might be more likely to take the case if it's an issue that's really not going to have much of an impact on the country as a whole. If the U.S. government asks the Supreme Court to take the case, they might be more willing to take the case. They don't have to. They're independent in what they choose, but if the government asks, they may be more likely to be influenced by that. Again, if it's an area of interest to like an individual justice, they individually might be more likely to vote that way to take the case. Like, again, if it's like a gender equity issue for years, that was like Ginsburg's area of sort of interest was gender equity issues. She would be much more likely to maybe vote to take a case if it involved a topic that she was personally passionate about. And then if there were just like awful, egregious legal errors made by the lower courts that heard the original case, they might be more likely to take the case to like rectify those issues. So again, this is the process of how a case gets to the Supreme Court. You have a right as an American citizen to have your case appealed, but it's up to the Supreme Court to decide if they want to take your case or not. They have complete control, and the odds very much are stacked against you ever having your case heard in the Supreme Court. Most of the cases that the Supreme Court can hear, they choose not to. It's only the rare few that ever appear in the Supreme Court.